Good afternoon. This is Eric Hauge, Executive Director of Homeline, and you're joining us again today, Thursday, June 4th, 1:30 p.m. to 2:30 for another installment of Homeline's series of webinars that we've been doing since about mid-April regarding tenant, landlord, and rental legal issues during the pandemic. And then today we will also be briefly covering a series of ordinances that were passed last year and went into effect in the city of Minneapolis on June 1st. And again, that will just be focused on Minneapolis. They are not in other cities at this point. Just a reminder, Homeline, we are a statewide nonprofit organization that provides legal advice to renters. And we have run a statewide hotline that advises tenants in English, Spanish, Somali, and Hmong. Again, we've been doing these webinars since mid-April, every Wednesday afternoon for an audience designed for an audience of tenants and service providers, and then Thursdays for landlords and property managers. And that's the information about our hotline. If you have tenants, you can refer them that way if they have questions. Again, we have been doing these for a number of weeks, and all of the seminars are available. The recordings are available on our website. At the bottom of that slide there is where you can get to some general information and also past recordings. So with that, I'm going to pass it over to Homeline's Managing Attorney, Mike Vraw, to start us off.
Thanks, Eric. And we're going to start by talking about the COVID-19 issues that dominate pretty much all of landlord-tenant law in Minnesota still. 10, maybe 15 minutes of that. And then we'll cover the Minneapolis-only ordinances. I'm not sure if you all received an email from us or contact from us saying that we were going to touch on those brand new issues, things that went into effect on the first couple days ago. And then after that, we're going to be answering your questions. We have a handful of questions that were pre-submitted before the webinar began, and I see that we already have one in the Q&A box. To send us a question, either type it into the Q&A section or in the Zoom webinar chat. Either way is fine. We'll see it and hopefully have time to answer it. I assume we'll have time to answer almost all the questions we get today based on what we've got so far. But if you have them, it's a good time to get in line and ask your questions. But to start, I'm going to cover the biggest topics in landlord-tenant law in Minnesota right now that are COVID-19 specific. Many of you are joining us for the first time, I'm guessing, based on the list of attendees that we saw in advance. Some of you are returning, and that's great. If you want to stay current, I certainly understand that. And what we're trying to do today, like we do every Thursday, is try to tell people what the rules are. We're just trying to keep people as updated as we can. This is really difficult information to process and understand exactly what it means. It's not like you can look up Minnesota landlord-tenant laws. Normally, what we look at to start with on a landlord-tenant law question in Minnesota would be a chapter of Minnesota law called 504B. That's the number assigned to that. That wouldn't do you a lot of good in trying to figure out the COVID-19 specific rules, because most of them are based on executive orders that are orders from the governor. You won't find those in the statute. You won't find the stuff we're talking about today in the Attorney General's Landlord-Tenant Rights Handbook. These are things that are just, they're publicly available. It's just people don't necessarily know where to look for them or how to find them. And so we try to keep both landlords and tenants as informed about what's actually happening today as much as we possibly can. So today, the shadow over the entire landlord-tenant legal arena is still the governor's executive order essentially banning evictions. So almost all evictions in Minnesota are for non-payment of rent. Well over 90% of evictions in Minnesota are for that reason. That's the reason the landlord is listed when they fill out the court complaint saying why the tenant should be removed from their home. those evictions for non-payment of rent, for a dog, for an unauthorized occupant, none of those evictions can be filed currently because of the governor's order. If you want to look up the order, it's Executive Order 20-14. There's actually a nice page. If you just Google up Minnesota Governor's executive orders, you can find all the executive orders in one spot, and it's pretty well organized. Anyhow, a landlord can still file an eviction in a limited number of cases if the tenant seriously endangers other residents, or if the tenant has violated a specific statute that prohibits illegal guns, illegal weapons, illegal possession of stolen property, prostitution. There's 4 items on that list, basically, and if a tenant violates one of those under that specific statute, then a landlord can still file an eviction. Those are the active evictions that a landlord can actually go forward with right now. And that's pretty much been the case since the eviction moratorium was instituted back in mid-March, when COVID-19 really started to take root here in Minnesota. Along with the ban on evictions, the moratorium on evictions, landlords are also not allowed to terminate tenancies during the peacetime emergency. So this is actually the first time I've used those 2 words, a peacetime emergency. The eviction order itself, the executive order covering evictions, is hinged in time on the peacetime emergency declaration that the governor made. And this is allowed under the statute, a state law that existed long before this, that said that the governor has the power to declare a peacetime emergency. And the eviction moratorium is tied in time to the peacetime emergency declaration. This is not to be confused with the shelter-in-place orders, which we've all seen in the news, the dials system that the governor has used for the last few weeks, talking about when restaurants can open, when salons can open, things like that. That's not related to the peacetime emergency declaration, which is the ban on evictions, moratorium on evictions. So anyhow, that is the key thing to be watching for. And we'll talk in a second about when that is up to be either expired, the eviction moratorium, peacetime declaration, or when it will be renewed. Before I get there though, a couple things. First, the rent for a tenant is still due. Even though a landlord is not allowed to file an eviction at present in Minnesota, the rent is still due. The governor's order is very clear about that, stating that yes, in fact, rent is due. When the COVID-19 epidemic first really hit and job losses were almost instant in several sectors, there was a lot of talk about rent strikes and rent cancellation, things like that. That has subsided substantially since then. Largely, I think, because many of the public benefits that tenants weren't sure that they were going to be able to get became available. And so I think more tenants had the money in their pocket to pay their rent, so they paid their rent. We've heard reports from landlords around the state that the numbers of non-payments aren't as bad as we had feared, which is great news. But as this goes on, the likelihood that tenants are going to be behind in rent or fall behind in rent increases, I think, every month. And we're in a new month now, June, and I'm sure landlords are watching their receipts to see what percentage of their rents are being paid. The last thing is the Attorney General's office is the office that has the job of enforcing this order. So if a landlord is deciding to try to evict somebody or terminate a tenancy during the peacetime emergency, the Attorney General's office has the power to enforce this rule. It's actually a misdemeanor, up to $1,000 for a fine and up to 90 days imprisonment. So it's a real penalty, and the Attorney General's office is enforcing this actively throughout the state. And they're certainly trying to talk landlords out of doing things commonly. It's one of the things that they're spending a lot of their time on, even on weekends, I've been told by both tenants and folks in the AG's office. All right, so let's talk about when the moratorium might end. So we've been hearing, if you look in the news, as we do, because we keep track of sort of things that are going around throughout the country sometimes. Many states have started to ease back into evictions being filed if they haven't opened it up completely, but not in Minnesota. Right now, the eviction ban that we have goes through June 12th, so that's next Friday. At that point, the governor could extend or the state legislature could extend it if they were in session, which I guess that doesn't really work. However, if the governor decides to extend the peacetime declaration, the law requires the governor to call a special session. And at that point, the legislature gets to decide whatever they want to talk about. They can bring up new bills that have never been heard before, I suppose, or work just solely on a couple of things. But the law requires that if the governor extends the peacetime emergency, that the legislature has the chance to end it. And the only way it can be ended by the legislature is if both chambers or both houses in the legislature, both the Senate, which is controlled by Republicans, and the House, which in Minnesota is controlled by the DFL or Democrats, agree to end the peacetime emergency. That's the only way the legislature has the power to stop the peacetime declaration extension, which they might do. We don't know if the governor is going to extend the peacetime declaration, although I think from some of the comments that the governor gave last night in his weekly press conference, or daily press conference, I should say, I think there's a real strong likelihood that this is going to be extended another month. It's probably the clearest signal I think we've seen since this all began of an extension in advance that was officially announced. But I can tell you, being a tenant advocate and one of the people that you might think might have some insight into whether the governor is going to extend this peacetime declaration, we don't know. We don't know. We've heard hints and rumors from lots of different sources on both sides saying the governor might end it, the governor might not end it. We don't know. I'm not sure that there's more than 1 or 2 or 3 people that actually are aware of that decision, if it's already made in advance. I mean, there's a pretty good argument for the governor to be waiting until the last minute to decide this every month, because it's not just about evictions. The peacetime emergency declaration does not just affect landlords and tenants. It affects a lot of different aspects of life in Minnesota. And so the governor, I assume, is looking at the most recent, most up-to-date, most current information available in order to decide whether to extend the peacetime emergency. All right, let's go on to the next page. Typically when I talk about landlord-tenant law, which I do a lot, I've given, I think, 1,200 speeches throughout the state to a lot of landlords, a couple hundred to landlords, and a lot to social workers and tenants and a lot of other folks. But one of the things I almost always bring up is how landlord-tenant law is almost all state specific. And today's session really shows that that's not always true. First, we're going to talk about some federal rules, and then we're going to be talking about some city-specific rules as well. So some rules that are sort of larger in scope than the state level, the federal ones, and then some that are more narrowly tailored for a specific city, in this case, Minneapolis. So the federal rule that I'm talking about today is something called the CARES Act. This was passed late March in response to COVID-19, and it bans evictions from being filed through July 25th. And it's not actually through July 25th. I mean, that's technically when the landlord has the right to evict, but then they have to warn the tenant first with a notice, a 30-day notice. So it's not really until late August that a landlord can file an eviction if the CARES Act is in play. And we'll talk about who that covers in a second, but the only types of evictions the CARES Act prohibits are non-payment of rent cases. As I mentioned earlier, that's well over 90% of Minnesota evictions. So it's not like much of a limit for what the CARES Act is applying to here. Almost all evictions would be covered by the CARES Act for the subject that they're talking about. However, the CARES Act only applies to certain buildings. And Eric, there you go, thank you. Where does it apply? Well, if there is a federal subsidy, then it's a sure thing that the CARES Act applies. Basically, any place that is covered by the Violence Against Women's Act, which is actually a specific reference in the CARES Act to show a broad umbrella of places that are covered by the CARES Act. And there's actually a way to find most of these larger buildings. There's a National Low-Income Housing Coalition has put together a pretty good list, and I think Eric will put it up in a second, showing which places are covered. In fact, it's on our chat box already. The larger buildings that are covered. But that's not all of the places that are covered by the CARES Act. Any landlord that has a building that is secured by a federally backed mortgage system like Fannie Mae or Freddie Mac would also be covered by the CARES Act. Our best guess is somewhere, I don't know, 20 to 50% of Minnesota landlords are covered by the CARES Act and are not allowed to file evictions effectively through the end of August. Now, on the smaller buildings, 1 to 4 units, whether there's a federally subsidized mortgage or not is actually a pretty difficult question, bordering on impossible for a tenant to know the answer to. So as you all know, evictions aren't really allowed to be filed in Minnesota right now. So we're not exactly sure precisely how Minnesota is going to deal with this question, but in other states where evictions, the doors to the eviction courts have been opened up already, most of them, if not all of them, are requiring that landlords swear under oath that they are not covered by the CARES Act. Because the landlord is the one entity in the world that can probably figure this out fairly easily. If I'm a landlord and I got a mortgage down the street at my local bank, I can go to my local mortgage provider and ask them, hey, look, I'm your customer, I'm paying on the mortgage, but I need to know the answer to this question. Is there federal backing, is Fannie Mae, Freddie Mac involved in my mortgage? And if they are, you wouldn't be able to file an eviction, even if the state eviction court doors opened up on June 13th, which would effectively be June 15th because June 12th is a Friday. So on June 15th, if the governor decides not to extend the peacetime emergency or somehow the eviction moratorium is lifted, the CARES Act would still have to be answered, that question, for any landlord thinking about filing an eviction. And once again, at the federal level, we have a Senate, just like in Minnesota, controlled by the Republicans, a House controlled, just like in Minnesota, by the Democrats. The president obviously is Republican versus the Democrat governor in Minnesota. But this law, the CARES Act, was enacted by the Republican Senate, the Democrat House, and a Republican president. That's who passed this law. Pretty bipartisan as things go. Now, the CARES Act isn't just about landlord-tenant law. There's a lot of detail in the CARES Act. I can't remember how many hundreds of pages it is, but it does specifically address non-payment of rent cases where the CARES Act should hold sway. Now, Minnesota courts, quick update on what they're doing, generally aren't being scheduled, like we talked about earlier, unless for endangering other residents, drugs, guns, etc. Something called an ETRA, an Emergency Tenant Remedies Action, can be filed by a tenant and can be heard by the court. So if they've got a toilet that doesn't work, no running water, no hot water, there's actually a specific list in the ETRA statute. A tenant can still get into court for that purpose. Also for a lockout, where a landlord has actually changed the locks on the tenant or removed the door or turned off the utilities to try to chase a tenant out that hasn't been paying. Although the Attorney General's office is getting involved in cases like that, which they're viewing as terminations of tenancy / evictions. So there's additional penalties, not just the lockout statute at this point. Rent escrows, which are the primary tool that tenants typically use to try to force a landlord to make repairs, are also not really being scheduled for new cases right now, cases that were filed before COVID-19. We're starting to see those start to be heard in the courts. So that would be 3 months later after the tenant filed them, that's when they're being heard. And the last court that really matters quite a bit for landlord-tenant law is conciliation court, small claims court. That's where landlords typically go to file a case for collecting money from a tenant. So if a landlord files an eviction in Minnesota and they win, they don't actually win money. A landlord wins possession of the rental if they win the eviction. If the landlord wants to try to collect the money from the tenant, they have to go to a different court, small claims court usually. You can sue up to $15,000. And at that point, attempt to get a judgment if they win. And if they do, they try to collect the money from the tenant. That's the most common case that landlords file against tenants in small claims court. And tenants also sue landlords in small claims court. The most common case there would be suing for the return of a security deposit. Those courts, again, not really open, not seen as a high priority by the court system at present. All of these courts are going to open up eventually. We don't know when exactly. The rent escrow conciliation court are not prohibited under the governor's order. It's just that the court, with a COVID-19 sort of awareness approach, closed a lot of courts in March, and now are trying to figure out which ones to open and when. But those are not hinging on the governor's order to reopen.
All right, so the next thing we're going to talk about, and we are going to have plenty of time at the end here to answer questions that were submitted in advance, and and those that are coming in live about any of these topics, pandemic related or Minneapolis specific. But for now, there are three fairly significant, important new City of Minneapolis ordinances that were passed over the past year, and that go into effect beginning June 1st. We're going to talk about three of them. The first one is about tenant screening and the application process. Again, this is only relevant to landlords and tenants that are renting properties in the city of Minneapolis. The first ordinance is around tenant screening. So it has a bit of a staggered approach for property owners that have 16 or more rental units, either in a single building or it can be through a portfolio of multiple properties. If there's 16 or more units, this ordinance has gone into effect as of June 1st. And it's a staggered approach for smaller landlords. So December 1st is when it will be relevant for smaller landlords that have 15 or less units. And again, that staggered timeline is only for this specific ordinance, not the other two that we'll talk about in a minute. And generally what the ordinance does is it gives landlords two options about how they do prospective tenant screening. They can either choose the inclusive screening option or choose the individualized assessment option. We're going to talk about the inclusive screening option first. All right, so the inclusive screening option identifies in the ordinance, and I will put in the chat once I'm done talking here, a link to some resources on the city website that provides a summary of this and also has links directly to the ordinances so you can look at them. It regulates a number of areas. The first is criminal history. So it limits a landlord's ability to look back at certain types of criminal history for different timelines. And it's up on the screen there. Misdemeanors over 3 years old, felonies older than 7, specific felonies older than 10, and there's an exemption for drug manufacture, distribution, and sex offender registry. The next area the ordinance looks at is credit scores. It basically has a blanket prohibition against using the credit score number alone to deny an applicant. You can use information in a report, such as rental payment history, etc., that might show up in a report, but can't use the credit score. And a lack of credit history also cannot be used against an applicant. The next area is income. So a common screening regulation that landlords use is income of 3 times the rent or higher. And if there is an income requirement being used, then the landlord must allow some type of ability for the applicant to show that they've had a history of good rental payments, even though that they don't have that level of income. And then the next section, the next section is around rental history, and basically governs, regulates when you can look at previous evictions. So previous eviction on a applicant's record cannot be used against them as an applicant if it was dismissed or the tenant won the case, if it was settled and no writ was issued over a year ago, or if the eviction is more than 3 years old. All right, and so now that's the first option. So landlords can choose this specific inclusive screening options that is very clearly laid out in the ordinance and in the materials that I'll send in the chat box in just a moment. Or landlords can choose this individualized assessment. So if the landlord wants to use a different type of criteria, they must go through a process of individualized assessment for each application for the basis of denying. And basically there's a process outlined in the ordinance, but the landlord basically has to allow the tenant to provide evidence, information, supplemental evidence that certain incidents nature, severity of incidents that would lead to a denial, the number and the type of the incidents, the time since incidents have occurred, the age of the applicant at the time of the incident. Sorry. And then in terms of inclusive screening, sorry, we're going through the denial section now. So again, the two rules are either inclusive or individualized assessment. If a landlord is denying an applicant, there's a timeline. They have to provide information within 14 days about the criteria that they failed to meet. Landlords are also required to provide as much information as possible to applicants before they're applying as well. And then if it's for criminal history, landlord does have to provide supplemental evidence if the applicant did provide it. The 14-day rule also applies within the individualized assessment section of the ordinance. And the landlord must state the basis for the denial and that any supplemental info that that the tenant provided was not sufficient. The rules also require that landlord retain records of this application information, and the City Department of Regulatory Services, that's the department that does inspections, they are tasked with enforcement of this, and so they are able to request records for up to 2 years back to ask a landlord to show that they've been complying with the ordinance. The next
Eric, if I could, this is complicated stuff, right? I mean, these are not really just simple things, and there is a change certainly from the prior rules for landlords in Minneapolis. What do you think our sense is of what landlords are going to choose since they have these two options to use? Do we have any feeling in your mind?
So we were going to be joined by Homeline's lead tenant organizer, Ivory Taylor. She wasn't able to make it today. She was part of the implementation committee when the city passed this. There was a community kind of work group team of different stakeholders that came together to prepare for implementation. And based on, I was not a part of that. Ivory was. She has a little bit more knowledge about it, but there is, there are vendors, tenant screening companies that were involved in that process, and so I think there is a lot of helpful guidance and information coming from screening companies, and their systems are going to be set up so that it will be easier for landlords to comply with this. I think it seems like it makes a lot of sense to follow the inclusive screening guidelines simply because they're laid out and very clear in the ordinance. And my understanding is that these screening systems, the companies that many landlords and professional property management companies use are really set up to provide a system that will run an applicant through the right screening criteria.
You're saying kind of a first step for Minneapolis landlord would be check with the screening company you're already using how to make sure you're complying with the new ordinance. Is that sort of a safe first step?
I would agree with that, yeah.
Okay.
And the next ordinance what we want to briefly mention is regarding security deposits. So again, Minneapolis-only, and this one, there is no staggered approach. This one was effective on June 1st. Basically, it limits security deposits to 1 month's rent. If it also allows for that if the landlord charges first and last month's rent up front, then the deposit must only be half a month of rent. Landlord must allow the tenant to pay deposit in a staggered timeline with up to 3 month installments. It has a couple exemptions. If the tenant was working with a nonprofit service provider or some type of government agency to help assist in securing housing, then the deposit can be up to 1 1/2 times the month rent. And then there is a requirement within the ordinance around complying with existing Minnesota statute 504B 178, which is the state law that regulates how security deposits work and the return of security deposits. And the city is obligated to create some form of written statement that outlines the tenant's right under that law and this ordinance, and that's supposed to come basically with the deposit, or with a letter saying you're not going to get the deposit back.
Right, and the city has to date not created anything like this. They haven't created some sort of official statement. If I'm a landlord right now and I'm figuring out a deposit in Minneapolis, my best advice would be to actually give the tenant a copy of both Minnesota Statute 504B.178. Again, that's the landlord tenant chapter, and 178 is the section that has the that has a security deposit covered, along with the Minneapolis ordinance. I mean, here's the ordinances. Here's the ordinance, here's the statute. I had to tell you, and here it is. And I think that that's probably got to be sufficient, as near as I can guess, under the Minneapolis ordinance.
Yep. And then the last ordinance that we want to talk about, again, only Minneapolis specific, is around relocation benefits, relocation assistance. And there's actually, the city already has an existing law that's already been in effect, that's very specific to the sale of what are considered affordable housing buildings and a timeline of tenant protection after a sale happens. And so if a landlord wants to terminate a tenancy within like a 3-month period of one of these sales of a specific type of building where it's got 5 or more units, where at least 20% of the units are affordable to households earning less than 60% of the AMI, then there's a relocation ordinance that goes into effect. That one's not really changing at all. The new one that's effective June 1st is very specific to instances where through the fault or the mismanagement by a landlord that has resulted in the city revoking the rental license, denying a rental license, or canceling it due to the condemnation of a unit. If that occurs, then the tenant is allowed to receive 3 months rent and in relocation assistance to address those types of situations. Again, it's only for situations where it's through the fault of the landlord and there's a revocation, denial, or condemnation happening. Earlier this week, the city, so this is in effect as of June 1st, but in the meantime, the city council is actually considering some amendments. They actually, I think a council committee just voted a couple days ago on approval of some amendments to this. And so it's likely that will pass the council. I think it would be within the next 2 weeks that it would be up in front of the full council to add a little bit to this existing ordinance. And what that does will create the same obligation to pay 3 months of relocation assistance in situations where the landlord never had a license, and so that therefore the city is the city, if there's no license, then there's an obligation for the city to vacate the units. And so this would then help those tenants in those situations where the landlord was illegally leasing the unit without a license, or in a situation where it already went through one of these processes. The unit was the rental license for the unit was revoked, denied, or condemned, and the landlord subsequently rented to a new tenant. So there was no license because it was revoked. And so that's the amendment that's happening on that front. I think that covers the Minneapolis ordinances. Again, those 3 that we just talked about are very specific to the city of Minneapolis, where renters and landlords are impacted. All right, so with that, not seeing any, I don't think I'm seeing any questions coming in about the Minneapolis ordinances. Again, I put in the chat box a link to the city of Minneapolis's website, where they've got summaries of a number of these ordinances and links to the ordinances. So with that, we will move on to questions that were submitted in advance. The first one, what is the best way to enforce pandemic best practices during showings without running afoul of discrimination claims?
Okay. Well, I mean, my starting advice, if you're trying to run or comply with all discrimination concerns as a landlord, is consistency, always. Set up a policy that's legal, and then make sure you and your employees slash agents always follow it. As far as I think what's buried in that question is sort of a concern about reasonable accommodation. If somebody says, hey, look, I don't want you in my home because I'm a higher risk level for COVID-19, I'm elderly or immunocompromised or something like that, then, well, I would probably be shooting for things like video showings to start with. In fact, I think that I know that a lot of landlords are doing nothing but video showings now, largely because of the time we're in. They don't really like the video showings. They'd rather show the place to the tenant in person. And in normal times, I'd be in favor of that too from the tenant's perspective. But right now, the video showings might be all that anybody gets. And that's what a lot of landlords are doing, is nothing but video showings. That's the cleanest way to do this to minimize the COVID-19 impact. If there does have to be showings in person, the realtor's approach when they're showing houses, all the lights are left on by the current tenant, all the doors are left open, the closet doors, the bathroom doors, so nobody has to touch things. At least it's minimized in that respect. And then everything's wiped down before and after. And when the landlord is showing the place and the new tenants are looking at the place, that they are wearing masks would be sort of, I think, the starting pieces of how to manage what tenants are expecting, current tenants are expecting from privacy when the landlord's using their key to enter, as well as the prospective new tenants, for a couple of reasons. Number one, if I'm an applicant and I'm looking at a new place, I'm going to want to be safe when I'm shopping. But I'm also going to be thinking, wait a second, this landlord is being really considerate about other people's health, showing me the place. They're probably going to be considerate about everything else. I'm not sure that landlords always think about selling like a lot of people in the sales world do. Maybe they do, maybe they don't. I can't really tell. The landlord-tenant relationship doesn't seem like the exact prototype of the consumer salesperson relationship. We rarely hear landlords refer to their tenants as customers. It's something else. I mean, if they're a customer, the phrase "the customer's always right," don't really hear that from the landlord side often, that the customer's always right. But a landlord is in sales. They are. And if a landlord is showing courtesy and awareness of the situation that we're all in, and is being respectful of their current tenant, a prospective tenant is going to see that. And they're going to be thinking, as they're shopping around for a place, hey, look, this landlord, cares about their current tenants. They're probably going to care about me if I'm one of their current tenants someday. So I think it's a way to actually help sell a place, because one of the things that a prospective tenant is looking at, or should be looking at, is what's my relationship going to be like with management here?
Right. So the next question, when can we begin processing evictions again?
Yeah, so I'm assuming this is for non-payment of rent cases. June 15th would be the earliest, if and only if on June 12th, the governor lifts the eviction moratorium tied to the peacetime emergency, or ends the peacetime emergency, or the legislature does so at that time. That's what it would have to take. And it could happen, but we don't know when that will happen. And we'll all know on the night of June 12th whether it's going to occur or not. I assume that we'll be posting it on our website as soon as it's available information. I don't think the governor will say on the night of June 12th or the afternoon of June 12th, evictions can't be filed still. Again, the peacetime emergency declaration is not just about evictions. There's a whole host of other issues that accompany that. But that's what we'll be looking for. Is the peacetime emergency extended, or is it lifted?
Yeah, and again, governor can wait till the end of that day on the 12th. It lasts until midnight, basically. Of course, the legislature will have to come back in special session, so there may be wind of what's going on at some point prior to it, but he has in the past waited till the end.
I think it was 6 o'clock at night last time. Yeah.
Next question: landlords that have 24/7 staff for youth being 18 to 24 years old, can the landlord not allow visitors due to the pandemic?
If it was in the lease prior to COVID-19 occurring, then I think a landlord could certainly enforce that part of their lease. Honestly, the only leases I think I've ever really seen in that vein are typically like domestic abuse shelters, where visitors are only allowed if cleared through the front desk staff or something like that. Almost no regular landlords in Minnesota have any kind of rules like that in place in their lease originally. So if a landlord wanted to implement a rule like that right now, it'd be really difficult to, I mean, it's hard to change a lease in the middle of the lease, basically. You've got a contract signed by both sides, everybody has to live up to it. So for a landlord to say, I have the right to suddenly exclude all of your guests, I don't think that would hold up if that went to court. I mean, the governor's shelter-in-place order has always had exceptions for visitors needing to go places for caring for family members, bringing groceries, bringing medication, things like that. And that list has just grown over as the dials have changed and what's allowable for contact with people. And so I think that'd be a really hard thing for a landlord to start instituting and enforcing in the COVID-19 world if it wasn't in their lease prior to that.
And the last advanced question we got is, can we non-renew a tenant's lease?
That's actually a really complicated question, and it all depends on the dates, honestly, is my first part of the answer. So if you had, as a landlord, given a tenant a notice of non-renewal that was supposed to take effect for the end of May, the tenant was supposed to leave by May 31. On June 1, if they're still there, you can't go file an eviction. The moratorium is still in place. And plus, you're terminating the tenancy during the moratorium. And I think there's an argument that if a landlord gives a notice of non-renewal right now for a time after when the moratorium is set to expire currently, they have terminated the tenancy during the peacetime emergency declaration. I think that's actually a violation of the governor's order. So up to $1,000 and 90 days in prison. My very conservative advice, again, I'm a tenant lawyer. All we do is represent renters and work with renters in our office. Run our tenant hotline where we talk to 15,000 tenants a year roughly. But if I were a landlord lawyer, I'd be telling my clients right now, hey, look, if you want to give somebody a non-renewal, wait until the moratorium is lifted, then give them a notice, whether it's a month or 2 months or whatever your lease requires after that time. That's the conservative, safest advice I can give on how to terminate a tenancy as a landlord.
All right, so we've got a handful of questions in the Q&A box, so we'll get to these. Again, feel free to submit more if you have them. First question, I understand why they are stopping evictions because of missed payments during this time, but why not allow evictions for other breaches of contract, for example, damage, smoking, drugs, etc.?
Yeah, and built into that question is the word why. I see it twice, actually, and I can't really explain exactly why the governor is doing everything that the governor is doing, but from everything we've gathered, the whole theory behind the governor's specific order banning evictions was, I think, twofold. Number one, a lot of people lost their jobs and it had nothing to do with job performance, right? I mean, entire industry seemingly shut down practically overnight and a lot of people were out of work. And so, and this was done, this eviction moratorium was done long before the additional unemployment benefits were really decided upon, long before the stimulus money from the federal government came through. And if you recall, there was a real concern about how long it was going to take to get that money to people as well. That's been a little more efficient than I think a lot of people thought it might have been at the time. And so people got that money in their pocket. The unemployment benefits started to happen more effectively and efficiently than we thought before. So one of the main purposes up front was, hey, look, these folks lost their job. It's not their fault they can't pay their rent. But the overriding concept, I think, behind the eviction moratorium is that the governor didn't want to have thousands, tens of thousands, maybe hundreds of thousands of people forced out of their home right now. Basically, the governor's giving orders saying, hey, look, shelter in place, shelter in place. Well, how can I shelter in place if I just got evicted because I couldn't pay my rent because I lost my job because the place shut down? So the governor made really narrow exceptions for when evictions can be filed right now. Basically, it's for violating the statute that we talked about. And drugs is on the list, by the way. If you find illegal drugs in the tenant's possession in the property, then you could still file an eviction. That was part of the question that we got. But smoking, damage, first of all, there are not a lot of evictions filed for those reasons. You might suspect that there are. You might think that's why landlords file. But if you look at the actual court papers, why do landlords file evictions? It's almost always for non-payment of rent. If there is an eviction for a breach of the lease, it's typically for an unauthorized occupant, the boyfriend or the girlfriend has moved in, or a pet violation. Those are the most common violations for breaches of the lease that are filed. Now, landlords threaten filing evictions all the time, but actual court case filings where the landlord pays $300 and goes down to the courthouse and says, "Judge, please remove them." Again, it's almost always non-payment of rent. Then if we lump in unauthorized occupants and pet violations, then we're up to probably close to 95%, if not higher, of all evictions in Minnesota are for those reasons. So there you go.
Can you give some examples of what is considered endangering the safety of other tenants?
I think this is sort of a, you know what, when you see it kind of thing in a lot of regards. I guess the standard that I would have in my mind, sort of as an attorney, I don't do work for restraining orders, orders for protection, things like that. It's not the kind of work our office does, but I know enough about it from pieces of questions that our clients have asked over the years to know that if you want to get a restraining order, what you have to allege is something typically like, hey, look, they attacked me physically. The person I want the restraining order against actually attacked me physically. They touched me, it was an assault, or they threatened to assault me. Something that clear would almost certainly rise up to that level of endangering the safety of other tenants, I think. And so that would be the standard in my mind that I would be having if I were either a landlord or a landlord attorney trying to decide, should I file an eviction right now? Can I win this case under the COVID-19 exceptions?
Next question is, does the governor's order banning eviction, does the governor's order ban eviction of residents by the county for non-payment of property taxes?
I don't know the answer to this one, I'm sorry. We just advise renters in our office, and I think you're talking about a homeowner and what their question would be, or a landlord. And so I don't know the answer to that question about whether that can be enforced ultimately or not. Sorry. I would check with the place called the Minnesota Home Ownership Center. They do a lot of work with homeowners, obviously, and if they don't know the answer, they probably know the person or agency that does.
Next question is, can we, as the landlord, give notice to tenants that if they continue to not pay rent, eviction paperwork has been prepared to file immediately when the hold is lifted? And can we offer an option for the tenants to elect to move out by X date without future legal consequences?
Okay, and Alyssa was the first name of that question. Oh, it just disappeared. Yeah, this is a really good question, and I think it's kind of the sensible question that landlords are going to be asking throughout the eviction moratorium, and then especially when the eviction moratorium gets lifted. Certainly if we get any advance notice of it at all, which I think almost everybody would like to see. There's a real chance that the governor, when the governor decides to end the peacetime emergency, won't give us any warning at all. It might just be announced, and then immediately a landlord could go file an eviction. I would hope that there's some sort of warning time, so there's a chance, more of a chance, for landlords and tenants to figure out, okay, that moratorium's gone, what's next? Because I mentioned this earlier today, when a landlord files an eviction, what they're doing is they're asking the court to give them possession. I mean, the easiest way to really visualize what a judge has the power to do in an eviction case is to think that everybody, the tenant and the landlord, both put all the keys in front of the judge. They put them up on the judge's bench. And then the judge at the end of the case decides who gets the keys. That's really the judge's primary and almost exclusive job in an eviction case, is to figure out who gets the keys at the end of this case. Now, sometimes the tenant gets the key, but it only works for a week or 10 days or something like that. But it's really about who has possession. And so if I'm a landlord and I've got a tenant that has not paid throughout the pandemic, the last time they paid rent was March, so they didn't pay April, they didn't pay May, it doesn't look like they're going to pay June, and the governor lifts the moratorium on June 12th. What are my options? Well, my options are to rush down to the courthouse, probably stand in a really long line with a lot of other landlords to file an eviction on June 15th. And I can do that, probably. We don't know. We don't know exactly how the governor is going to end things. Maybe there will be a notice requirement. We aren't sure. But let's just say that there is not a notice requirement. But is that the best strategic move for the landlord? Well, okay. If the landlord goes and files that eviction against the tenant on June 15th because they can, the reason why they're doing it, if they've thought this through, is they're trying to cut their losses. They think that the tenant who didn't pay during the entire pandemic isn't about to give them any money now. And they might be right. I mean, they might be correct about that. Maybe the tenant won't return their calls or their texts. And so the landlord is figuring, I got to get somebody in here who's going to start paying the rent. The only way I can do that is if I remove the one that's not paying the rent. But that landlord is already out 3 months of rent, right? Let's just use $1,000 because the math is easy. So they're out $3,000. If the landlord goes and files that eviction, it's going to take, on average, 20 to 30 days to get the tenant gone. Filing the eviction costs $300 more, just the act of filing the case. Now, that doesn't talk about whether the landlord gets an attorney or not. In most cases, it's not required. So a lot of landlords like to hire an attorney, so you're talking about several hundred more on top of that. So we're closing in probably on the $4,000 mark. And it takes 20 to 30 days on average to get a tenant out pre-COVID-19. How long will it take in the post-COVID-19 era, at least right away? If our fears are realized and there are thousands, if not tens of thousands of evictions filed right away once the moratorium is lifted, I think the odds of the landlord getting their tenants out in 20 to 30 days go down quite a bit. I don't see logistically how the courts are going to be able to process that. Normal years, there's 15 to 20,000 evictions throughout the entire state, throughout the entire year. So if we had 15,000 evictions in 1 week, you can see why the courts would be really struggling to be able to meet these demands. In fact, the legislature has been enacted now that gives the courts more time to try to satisfy statutorily imposed deadlines. Now, I know that the housing court in Hennepin County has said, oh, we're still going to meet it, but that's quite a promise if there are thousands, if not tens of thousands of evictions filed in the first week. I don't know how they can possibly do that while still actually having meaningful court cases, especially with all the potential for Zoom issues and phone issues, whether it's going to be in-person cases. I just don't know that it's going to be a 20 to 30-day process. So the question has a built-in sort of common sense analysis of what's going on right now, which is, what do I get if I file the eviction? How fast are they going to have to go? What's my other options? Well, I could do a pre-filing mediation of some type, and that might mean, hey, tenant, if you leave by this date, I won't file an eviction. Now, a landlord can't file an eviction against a tenant if the tenant is no longer in possession. They'd actually have to lie under oath to file that eviction, nor would you want to as a landlord. You'd be wasting your $300. You'd already have possession, which is the only thing the judge can really give you in an eviction. The bigger offer from a landlord in that situation would be, hey, I know you owe $3,000. I'm going to wipe out your debt if you give me the keys on this day. Now, I know that's a huge concept for a landlord to think about and a massive financial sacrifice, but it may be in your best interest if you want to get somebody else in there right away paying, because that tenant that you're evicting, whatever money they have, they're going to be using probably to get their next place, right? Because they have to prioritize the roof over their head that day. Now, I'm not saying they won't try to pay you back someday. Maybe they will, maybe they won't. But who knows what the economy is going to look like? It might take years if you ever see that money, if you ever do. I mean, you get a judgment and it has an effect on their credit for sure, but that doesn't necessarily put money in your pocket. So I like the question. It's a really common sense question, and it's a landlord who's trying to figure out what's the smartest move, not just for me, but I mean, what's the best move for the tenant too? Because I should be talking to the tenant about what works best for both of us, because that's what's going to convince the tenant to go along with any kind of settlement concept. But I think a lot of very smart landlords around the state are going to be asking that exact type of question when the moratorium is lifted and between now and when that happens.
All right, we got 3 or 4 that have come in here. So
I'll try to make the answers shorter. Sorry.
Yeah, no, that's all right. I think this one might be about the security deposit, Minneapolis specific. So if we collect first and last month up front with this new Minneapolis ordinance of limiting the deposit to half month rent, doesn't it seem unfair to the landlord as the rent as the rent covered the rent, but we usually don't know about damage until the tenant's moving out or moved out. And then the landlord would not have the funds for, to cover the damage. This would make for more lawsuits to collect damage that would have been deducted.
So the fairness question, hard to answer that. I mean, we are where we are. Leave the question on the board too, Eric, until I get through it. I want to make sure I can see it. Thanks. The ordinance is enacted. So the fairness question on a lot of levels doesn't really matter right now. Logistics do matter though. So built into your question is a supposition that you already charge the first and last month's rent. And that's legal in Minneapolis still. And then it limits your deposit to half a month's rent. So again, using the $1,000 rent, you're asking for $1,000 for first month's rent, $1,000 for last month's rent, and $500 for the deposit is the most you can charge in that situation. So you still actually end up with, I guess, more money in your pocket up front. If the tenant disappears midway through the lease, you've got more of an insurance policy. But not every landlord asks for the last month's rent. It's not a requirement. And if I'm summarizing what landlords do in the state, I would say more landlords don't get a last month's rent than do. And I look at leases every day, different leases from all around the state. So it's not the standard, or I think even the norm, for landlords to insist upon a last month's rent when a tenant moves in. I mean, look, you're right. Limiting the deposit is going to make it so a landlord might end up suing more in conciliation court for damages that they think the tenant caused. But that's the rule we have. I think the concept behind the rule that the city council passed was they wanted to lower the barrier for a tenant to actually get access to housing. That was the theory behind the application fees change, and certainly behind limiting how much a landlord could demand in a deposit situation. And I can say, as a tenant advocate that's done this for a long time, most landlords, decent people. I always say 95% of landlords are decent people trying to do the best they can, but 5% aren't. Those 5%, the 5%, the worst landlords, the most abusive landlords, the ones that give all the good landlords, really, honestly, that tarnish, are ones that keep almost every deposit. That's sort of a standard MO that they use. And so in my mind, it's one of the most abused things by the worst landlords. Now, again, if you're a landlord watching this, chances are you're trying to figure out what the rules are and you want to play by the rules. And so you're impacted by this. But this is the new rule in Minneapolis. And so understanding it is the first key. And that's what we're trying to help you do now. Okay, thanks. You can go on to the next one.
Yeah, there's one that came in the chat. We have had many complaints about the pool not being open. We don't feel it's safe per the governor's order. Is there any issue with not opening it yet?
Yeah, I think there is an issue with not opening it. I think there's an issue with opening it too. I don't envy a landlord being in this position. We've heard questions about this, about all kinds of amenities, by the way. So from hey, look, I'm a member of the public too. So I don't want COVID-19 going everywhere. And I think opening your pool probably is the wrong idea right now. But it's a promised amenity in your lease or in your advertising materials. When you did the showing, people saw the pool. And so my advice to landlords when it comes to amenities that you're not able to offer right now or provide, the ones that you promised, is I would give a reduction in rent. And I don't think it has to be a lot of money. I think it could be, you know what, we had to close the pool, we had to close access to the party room, we're sorry about all that, and whatever other amenities you might have. But in exchange, we're giving you all $25 a month off your rent. Now, that's not going to destroy your bottom line. It just won't. And it is good customer relations. It's a chance for you to say, you know what, we'd love to be able to do more, but we can afford to do this. We know we're not providing you everything we promised, and that really is for everybody's safety, but we're going to knock a little bit off your rent in exchange for the fact that you can't use the pool. And it's just much likelier to keep the customer relations good, because you should care about that as landlords. I mean, you don't want the bad reviews on Yelp. You don't want the angry Facebook posts, and you don't want people leaving at the end of their lease. I mean, turnover is a huge cost for landlords. Most landlords fight to stop that. And I think this kind of goodwill, which wouldn't cost you a fortune, would still go a long ways in that regard. I think it's kind of like advertising in a way to pay for advertising for your own clients for the future.
Yeah, so the next one, tenants not responding to text messages, calls, or emails to inspect the property. What right does the landlord have to enter the property if they do not respond in any way? Can I knock on the door to give a 48 hours heads up for entry? What else should I do to gain entry?
So if this were not the COVID-19 era, I'd say, yeah, you'd send a text, you'd put a note under the door, and then you'd knock on the door, and say who you are and why you're coming in. Then you'd use your key, probably bring a friend and a camera to make sure this is all being videoed, and you'd announce who you are as you open the door to make sure that the place hasn't been abandoned. In the COVID-19 era, it's a little bit different. And I'm not sure why your tenant's not responding. Maybe they don't have the rent, and a lot of times tenants simply try to hide when they don't have their rent money, which right now isn't really necessary because of the governor's order, and they might not know that. But if your goal is to figure out, is somebody alive in there still? Is everybody safe? I think you could still go in. I'm more concerned from the COVID-19 aspect. I guess a really careful thing would be to say, you could call the police and say, look, I'm worried about this place. I don't know if anybody's hurt in there or alive or not. And I don't want to, knock on the door and scare them. Can you send somebody out? And the police might be willing to do that. I'm not sure. The police are pretty busy right now, obviously, but maybe they'd be able to do it. But you could send one last text saying, I'm going to be coming in. If you're going to go in, I would send every form of communication you can, naming a specific date and time that you're going to pop in, just for the purpose of confirming that folks are still there and to make sure that they haven't abandoned the place and that everybody's okay.
All right, and the last question here. Tenants will be moving out on an agreed date, which is earlier than the lease end date. Does the landlord need to go to small claims court before going to the route of a collection company to collect the unpaid rent from the tenants?
Honestly, in most situations, landlords do either or when it comes to trying to collect from a tenant. They'll either hire a collection agency or they'll go to small claims court. The downside to a collection agency, in my mind, is they charge you something. They get a percentage of what they collect. And so I'm not sure how much sense it makes to go with the collection agency approach. If I'm defaulting to sort of what landlords do, the bigger the company, the more likely it is they turn it over to a collection agency. The smaller the landlord, how many units they have is what I mean by that. The more likely it is that they'll go to small claims court. That's not an exclusive rule in either direction, but that seems to be what we typically see most when it comes to trying to collect rent from a tenant.
All right, so I think that's the last question we've had submitted. So thanks all for joining us again. We'll do this again as planned next Thursday at 1:30. You'll get a follow-up email with a link to the recording of today, and as well as registration for next week. And with that, we'll say thank you and have a good rest of your day.